It's close enough to 1 o'clock. I'd like to call to order the July 20th, 2026 meeting of the Board of Zoning Appeals. Ms. Parker, do we have a quorum?
Yes, sir, Mr. Chairman, we do have a quorum, and for the record, Mr. Rosenberg, alternate of the BZA, is serving in Mr. Lacey's absence.
Thank you.
Our next item of business is review of amendments to the Board of Zoning Appeals bylaws. Ms. Spalding, Deputy County Attorney, will go over the proposed changes.
Thank you, Ms. Parker. Again, I'm Alexandra Spalding, Deputy County Attorney, and I believe I have mentioned this to every one of you, but I will be now sitting with the BZA. Mr. Rennie will no longer be working with you, and so I'm looking forward to this privilege, and I appreciate your time today. I came before you at your last BZA meeting to undertake changes to the bylaws related to Virginia code changes, and because I've now been made the attorney for the BZA, I went through the bylaws and decided that there were some matters that just needed to be expanded on a little bit with regard to the hearings and variances and appeals, one of which you're doing today. So I made amendments to Article 4, which has to do with variances. You should have a copy of that with the red line showing you the changes I made, and they're really quite minor. I didn't change the order of anything. I just expanded the detail so that people would know, citizens in particular would know what they were entitled to do in a variance and in a appeal. And both of these sections have been, again, just minorly amended to clarify for citizens and for the board as needed. So I would ask for your approval on that in regard to the bylaws. I'm happy to answer any questions.
Thank you. I know we had spoke before that the order of things didn't seem to match what we were doing, and so that probably is part of what prompted it, but I don't have any comments or thoughts, and I'll look to the board if they have questions or motions.
Motion to approve?
Second.
Ms. Cook, motion to approve, and who's that down there? Okay, which direction that came from. So Mr. Boatwright did the second. All those in favor, or shall we do a roll call?
We can do a roll call for
Okay.
clarity. Ms. Cook?
Aye.
Mr. McDonald?
Aye.
Mr. Rosenberg?
Aye.
Mr. Boatwright?
Aye.
Mr. Babbitt?
Aye.
Thank you.
So the ayes have it, and that motion will pass, and we will move on to our next order of business, which is a preliminary hearing on the timeliness of an appeal. That would be for AP-2026-00005.
And that is application for appeal filed by Big Daddy's Oilville Office Land Holding Corporation, LLC, with Goochland County Board of Zoning Appeals. The document submitted purport to appeal the notice voiding the plan of development, POD 2024-19, for 1164 Tri-County Drive on tax map number 45190240. Issues to be determined include whether the appropriate materials were timely filed to submit an appeal and voiding the POD pursuant to County Code 15326.
Just take a moment to explain the light system that we have. When you're speaking, the green light will indicate the start of your time, the yellow light will indicate that you're coming to the end, and the red light will indicate that your time to speak is complete. Would the county's representative please come forward to provide opening remarks?
All right, my name is Tiffany Hightaffer. I'm here to present for the county. I'm the Assistant County Attorney for Goochland. I also have here Tara McGee, who's our County Attorney, J.M. Whalen, who is our POD Administrator. I also have behind me Sarah Worley, who is our Deputy County Administrator. And to my right, I have Jamie Sherry, who is our Planning Director. I'll be brief, as my presentation will cover most of this. Before the board may consider Big Daddy's, and I'll just say Big Daddy's for short, substantive appeal, the board must first determine whether the appeal was timely filed. And it has to be within 30 days from the issuance of the notice of voided POD. POD is short for Plan of Development, in accordance with state law and our county ordinance. The notice of voided POD was issued on March 6th of this year, 2026. So the 30-day appeal deadline would have been April 6, 2026. April 5th would actually have been the 30 days, but that was a Sunday, so you would get until Monday to file, which would have been April 6th. Big Daddies attempted to file their appeal on April 9th. That would have been 3 days after the appeal deadline. The 30-day appeal period established by the state code is mandatory as well as jurisdictional. What that means is, if the board determines that Big Daddies did not timely file the appeal, then the board lacks jurisdiction to move forward on hearing the substance of the appeal. I will close and let Mr. Weiner do his opening for Big Daddies.
Thank you very much. Would the appellant please come forward to provide some opening remarks?
Sorry, I was just scribbling a little
That's
note for
just
myself. Good morning, everybody. Evan Weiner, Big Daddy's Oilville Office Land Holding Corporation, LLC. No, it's a mouthful, I'm sorry. Mr. Chairman, members of the board, thank you for the opportunity to address the preliminary issue before the board today. At this moment, the hearing is limited to whether the appeal was timely filed. We're not talking about the facts of the case yet. The evidence will show that within the applicable appeal period, I provided the BZA secretary with written notice that I was appealing the POD administrator's decision. That communication identified the appellant, identified the decision being challenged, explained the grounds for the appeal, and included evidence concerning payment of the required appeal fee. The evidence will also show that the BZA secretary understood what that communication meant, and that there was not uncertainty about whether or not I intended to appeal, that there was not uncertainty about whether I intended to appeal and what decision I was appealing. The facts will state that after receiving the notice, the BZA secretary began processing the matter as an appeal. The BZA secretary and the zoning administrator acknowledged the payment, provided the BZA's official appeal form, continued communicating about the appeal, and accepted the form once it was completed. They also assigned an appeal number to the matter, open administrative record, and then subsequently scheduled the appeal for today, which is why we're here. The evidence will also show that the BZA's official appeal form is not available in any way outside of directly contacting a staff member here at the county. There was no way on a Sunday when the appeal was due to obtain that form from the county's website, which in 2026 might seem like a reasonable way to have a form available for a citizen. Almost all of the forms are available on the county website. This one particular one is not. The evidence will also show that after my initial filing, the zoning administrator took the position that the appeal could not proceed because the official form had not been used. The official form is not required by statute to initiate the appeal. Per the BZA's bylaws, that form is required for the BZA to consider the appeal. I'm not asking the board to disregard its procedures. I complied with the board's form once it was provided. The question is whether the timely written notice received by the BZA secretary, followed by prompt completion of the BZA's additional paperwork, was sufficient to preserve the appeal. The evidence will also show that communication advising that the appeal could not proceed did not cite any provision of the Code of Virginia requiring the board's official form to initiate the appeal. The evidence will also establish that the BZA secretary received timely and unmistakable notice of the appeal, understood that an appeal had been filed, and acted upon it accordingly. Sorry, I'm skipping some stuff. This case is ultimately not about whether I completed the BZA's appeal form. I did. It's about whether my timely written notice on a Sunday afternoon, which the BZA secretary appears to have understood and acted on as an appeal, was sufficient to preserve my appeal rights until that form could be completed. At the conclusion of the evidence, we'll respectfully ask the board to find that this appeal was timely filed, that you have jurisdiction to hear it, and that this matter should proceed to a hearing on the merits.
Okay, thank you. I have a couple questions, if you wouldn't mind.
Anytime.
One
Yes, sir.
question, maybe circuitous question.
Yeah.
On March the 6th, which was when the letter was written by the county regarding the development plan, there was also a letter apparently regarding some building code violations that you received on the exact same day, which you filed an appeal on that one the same day. I'm curious
Actually, it's
how
not.
that happened. Is
That's actually not correct.
Okay.
And we'll depending on the timeliness, I think that there's some other, there is another topic that I'll raise about the record and what is and is not included. We received a copy of the record a week ago. I found at least one inaccuracy in the record, and you're bringing it up right now. So the day before the POD was voided and the building official issued a stop work notice, that is when I filed the first appeal. And I have a copy of that appeal with me. It's in the record as well. It shows where staff, I'm not sure who it was, but someone for county staff wrote the appeal number on the appeal form. And you can see where they wrote in there, received in Goochland, with the date of March 5th.
So let me rephrase it slightly. When did you know that the county had voided the POD?
March 6th at about 4:30 p.m.
Okay,
Friday afternoon.
gotcha.
Great way to start the weekend.
Right. All right, thank you. Any other questions? Sorry. Okay.
I have some questions for the attorney.
Yes, sir.
I think that'd be fine. Go ahead.
Thank you. I have a question, and it's regarding the notice of violation. It was issued on March 6th.
Correct.
Is that correct?
Yes.
I guess my question is, according to the state, there's a slight discrepancy between the state statute and possibly Goochland's, the ordinance. Goochland talks about the issuance date as the beginning of the 30-day period for a notice of appeal. In reading the state statute, however, it talks about the posting date when it's posted at the post office by certified mail.
Can you point me to that code section for the Virginia code on what you're referring to?
Um,
Because the ones that are applicable,
And the state statute is,
That would be 15.2-2311.
10,
Page 156 in the binder.
okay.
I was going to bring that up, but I was going to do that. after.
10H.
Written order.
Basically says that a statement informing the recipient that he has the right to appeal the notice of a zoning violation or written order within 30 days in accordance with this section, and that the decision shall be final and unappealable if not appealed within 30 days. Then in the following sentence, it says, the appeal period shall not commence until a statement is given and the zoning posted at the last known address, regarding the filing of an appeal. The appeal period shall not commence until the statement is given and the zoning administrator's written order is sent by registered or certified mail.
Yes, and that sentence is two parts. The appeal period shall not commence until the statement is given.
Yes.
And then it tells you how the written order shall be sent.
So it doesn't matter,
Because if you go farther down, it says the appeal shall be taken within 30 days after the decision appealed from by filing with the zoning administrator. So it has to be the decision 30 days from the decision. And it talks about that if you go to, let's see here.
it says, okay, so this statement is given and the zoning administrator's written order is sent by registered or certified
Yes,
mail.
so it's telling you how it has to be
The date it's
sent.
actually sent is not relevant?
No, because it would be difficult to calculate knowing when the person has received it. So it's the date that the notice is issued, the determination is made. So if you go up a couple sentences prior, it says, where it has the date, July 1st, 1993. It said, shall include a statement informing the recipient that he may have a right to appeal the notice of a zoning violation or a written order within 30 days in accordance with this section, and that that decision shall be final and unappealable if not appealed within 30 days. So everything that the statute is referring to is the decision, the date of the decision.
But in the next sentence, it says, the appeal period shall not commence until the statement is given
Right,
and the zoning administrator's written order is sent
yes.
by registered mail.
And if you also look at the Voorhees case, which is in section 10 as well, on page 179, where the court looked at this, and it talked about the petitioners did not, on the very last column, the last 4 lines, it said petitioners did not file their appeal until May 23rd, 2007, more than 30 days after the approval of the grading process. So even in that court decision, that was on April 20th. They're all working off the decision, but the statute is still telling us how we need to send the notice so that we can ensure the person has noticed, that they're aware of the decision.
Okay, thank you.
You're welcome.
I'm sorry, one other question, or maybe a point of discussion, because it seems like the other part of the discussion here is the form.
Yes.
In the method of notification. The appellant used an email and dropped off the check. I guess,
Ms. Cook,
is there a
maybe we
reason?
could save the discussion until after the applicant has made his rebuttal and
Oh.
we've gotten to that point, maybe.
I think we've also skipped over
Okay,
Yeah.
sure.
Well, we have the presentation.
Yeah, I feel like we're kind of getting ahead of ourselves a little
So
bit.
I would be happy to answer that now, but I do cover that fully in the presentation, so it's entirely up to you, whatever you prefer.
No, I'll wait, that's fine.
All right, thank
Sorry.
you. Any other questions? Okay, thank you.
And I think we are at the point where you give your presentation.
Okay. I didn't want to jump ahead of the gun.
Thank you.
I want to give you guys a supplement, because 2 pages were left off in copying. So I will, if you look at page 39 in your binders, you are missing 2 pages. And if you're reading it and were confused, I apologize, but give this to Evan. Really, I just did that to see if y'all are paying attention, and you guys all passed. You did great.
This says missing date.
Well, it did appear later.
Yeah, it was there later.
All right.
It's in the, it was actually in the packet on the website, so.
All right. I have a tendency to talk fast. I will try to go slow today. If I go too fast, please just let me know. I don't mind you telling me that. All right. If you look at the presentation here, oops, I didn't do so well. There we go. Okay. So the property at issue that we're all talking about today is in District 3. It's actually located in the Oilville Industrial Park, and it is zoned Industrial General M2. Let's see here. You can see on the vicinity map where this property is located, and you can see on the zoning map in the Oilville Industrial Park, when you come in, you can see where 1164 Tri-County Drive is located. This is an aerial view of the property. And you can see it has surrounding neighbors behind, to the back, and to both sides, and then the road along the front. Procedurally, on June 3rd, 2025 is when Big Daddy's received an approved POD. If you go to your record number 1 on page 18, you can see the letter that Big Daddy's received saying, the plan of development, and a lot of times you'll hear us say when we're talking about plan of development, we'll shorten it for POD, or we may reference it as site plan. They all mean the same thing. And so I'll probably just say POD for short. And it says, has been reviewed by staff and is approved. On March 6th, the POD administrator determined to revoke the POD and sent a notice voiding the POD. And that's record 4. If you look at page 46. and this is what the notice looks like. And you can see at the top, it has a date of notice on March 6th, and that's actually when it was put in the mail as well. On April 6th, that would have been the 30-day deadline. That's in, we talked about in Record 10F, required by the code, and our own county ordinance, Section 15-492, says appeals must be taken within 30 days of the decision, which comports with the Virginia state law requirements. They are not in conflict. On April 9th, 2026, Big Daddy submitted an appeal of the POD administrator's determination. That's in Record 5 on pages 86 to 112. Now, the actual application are pages 86 through 88. And you can see it's dated April 8th, and we'll talk about that in a minute. And then all of the supporting documentation. This hearing was properly scheduled and notified, and you can see that. It's record number 7, shows the actual public hearing notice. Additional record documents are the POD Administrator Staff Report, which is Record 8, the Memorandum in Support, which is Record 9, and then applicable laws, cases, and resources on Record 10. And I will also, when we get to it a little bit later on Record 10, you mentioned about the form, and we'll discuss that, why some other counties' forms are in there as well. The first issue that we have to decide is the timeliness issue. And the POD Administrator respectfully request that the BZA hold that this appeal was not timely filed. State law and county ordinance actually mandates that Big Daddies file their appeal within 30 days of the POD administrator's determination. That's back to that notice dated March 6th, and that's when it was issued. The BZA bylaws actually tell you about the form. Look with me to page 10. Page 10, and I mentioned this in some of the materials you'll see 5.3, that section. Also in 5.2, I'd like you to look to the sentence kind of in the middle that starts off, such appeal shall be filed with the zoning administrator on the form provided by the board. Section 5.3, last line. No appeal will be considered by the board unless it is made on the form required. Big Daddy's April 5th email does not qualify as an appeal application, and it does not qualify as being timely filed. This is the notice of POD, the voided POD. If you look on page 46, sorry we're jumping around so much, I'll go slow. But if you look at page 46, the last paragraph under notice of appeal, it says, you have the right under, and it gives the code section, 15.2-2311, which we just discussed, of the Virginia Code, to appeal this decision to the Goochland County Board of Zoning Appeals within 30 days of the date of this notice, which complies with the Virginia State Code. Any decision not appealed within the 30 days shall become final and cannot be appealed. It goes on to say, to appeal this decision, you must submit a notice of appeal accompanied by the $450 appeal fee to the BZA secretary. It then says very clearly, notice of the appeal form is available from the secretary and the community development office. Tells you exactly where to find the form. Not on our website, not anywhere else, but go into the secretary. Big Daddy's has experience, recent experience, filing appeals with the county. In fact, that was even just discussed a moment ago, in March, around the same time as the issuance of the notice of voided POD, Mr. Big Daddy's received an NOV, a stop work order, and a rejection of the retaining wall, also in March. The same time that emails were transpiring between the BZA secretary and Mr. Weiner, there were also emails about the LBBCA appeal. The forms, which also are not on the county's website and had to be sent to him, just like the form for the BZA. To file an appeal, you have to go through the same process. It's a 30-day deadline. You have to submit your form timely with your fee, not any different. Mr. Weiner had filed 3 of these. If you look at record 6, turn with me to page 113. This is the first appeal he filed. You'll note the review decision was made on March 4th of 2026. If you look at the bottom of the page, it says filed at Goochland on March 5th. He didn't even wait the 30 days. This was he was appealing the rejection of a previously approved engineered plans for a retaining wall, which is what we're at issue here on this appeal. Look over at page 122. This is his second appeal he filed with the LBBCA. Note the date. The review decision was made on March 6th. If you look at the bottom, it was filed with the county on April 5th. Same time frame as the one with the BZA. Look on page 126. This is his third appeal with the LBBCA. You can see the decision was made on March 6th, was filed with the county on April 5th, all using a form provided to him, all within the 30-day timeline. The appeal deadline for this instance, this appeal, was April 6th. Because it fell on April 5th, a Sunday, he got until Monday, April 6th. Staff received Big Daddy's appeal application on April 9th. That would have been 3 days later. In the case of Voorhees versus County of Fairfax BZA, if you look at page 179, and I referenced this earlier when Mr. Rosenberg asked his question. If you look at the last column, the last 4 lines, it says petitioners did not file their appeal until May 23rd, 2007, more than 30 days after the approval of the grading plans on April 20th, 2007. The BZA did not err in denying the appeal as being untimely. 3 days, just like this case. Now, Mr. Weiner will probably argue that he filed it on April 8th, because we noted when we looked at his appeal application, I mentioned that it's dated April 8th, which I referenced to you earlier on page 88. The problem with that is it came in after hours, after 5 p.m. We're closed. We can't receive it and we can't process it. And the county's policy is if it comes after close of business day, you get it the next business day. FOIA does the same thing. We get a request on one day. With FOIA, you count it as the next day. Even if he argues that it came in on the 8th, that's still 2 days late. And the Voorhees court said, if it's 3 days late, it's untimely filed. Since Big Daddy's appeal was not timely filed, the BZA has no jurisdiction to proceed to the merits of Big Daddy's appeal. I will stop here, and Mr. Weiner can present unless you have any questions.
Not at this time for me.
Thank you for your time.
Thank you. Mr. Weiner, if you'd like to have your say.
Yes, appreciate it. I should also add, I'm not a lawyer. I don't pretend to play one on soap operas, so I'm good at arguing, but I was about to say, and Tara would vouch for that, so I apologize if I'm a little discombobulated. So I want to touch on one thing first, kind of picking up Mr. Rosenberg, where you were about the notice, okay? I'm sitting there listening to what the attorney for the county is saying, and I'm like, we're leaving out the word "and," you know? It doesn't say, you know, there's not ambiguity in there. The statute, and I'll read it again, shall include a statement informing the recipient that he may have the right to appeal the notice of a zoning violation or written order within 30 days in accordance with this section, and that decision shall be final and unappealable if not appealed within 30 days. And this is where we get to the important part. The zoning violation or written order shall include the applicable appeal fee and a reference to where additional information may be obtained regarding the filing of an appeal. The appeal period shall not commence until the statement is given, and the zoning administrator's written order is sent by registered or certified mail with proof of delivery, and so forth. So the question I have for you to start off with is let's say Mr. Whalen makes a decision on Monday at 2 o'clock, and he doesn't send me an email until Thursday. So, according to this interpretation, that clock starts on Monday at 2 o'clock, not on Thursday when I'm told about it. So it also leaves out, it ignores the word "and" in that sentence. It doesn't say "or," it says "and." Both of those things have to be done. There has to be a decision, and it has to be sent by registered mail. Okay. So then also, if you'll refer to page 47, Exhibit 4B, the certified mail receipt, you can see that it was delivered on the 13th. I'll tell you, I didn't sign for this. That's not my signature. That being said, I'm not going to split hairs over whether I got it or not on the 13th, okay? But what is it also missing? It's missing the postmark. What documentation does the county have about when they mailed this? I mean, isn't there a box on that certified mail receipt for the postmark for a reason? So if council wants to say, oh yeah, well, we're going to split hairs over the box not being checked the right way, well, they didn't even check the box on getting it postmarked, so they have verification that it was sent. And I have a lot of stuff for this. Getting into my experience with appeals, yeah. I have some experience standing at this podium right here. I wish I didn't, but unfortunately I do. Council talked about the form for the LBCBA. There's a reason it doesn't exist on the county's website. The county doesn't have their own form. The county referred me, Ms. Worley referred me to the state's form, and that's what was provided, which is also available on the state's website. So if council wants to say that the form was provided to me, it was as a courtesy, but it was available elsewhere. And the reason why it's not available on the county's website, at least it wasn't at the time, the county didn't have their own form. The form that you see in the packet is the state form. That's why at the bottom where it says filed in Goochland, there's a blank, and staff wrote in Goochland. Otherwise, it's assumed that it's filed in Goochland County, right? Ultimately, like I said, I'm not a lawyer. I understand that there's this thing called the Dillon Rule. Basically says that that locality can't pass an ordinance or a law that supersedes, or a policy that supersedes state code, right? So the state code is very clear about what's required to file this appeal. And on a Sunday afternoon, when I finally had time to sit down and, I knew what had happened. I didn't need to read the fine print, but on that Sunday afternoon when I sat down to make sure that I had it submitted in time, I didn't expect to see that I had to talk to Ms. Parker, who she's great, don't get me wrong. She's amazing. We go back a minute and, she's a gem. But I shouldn't have to call her or come by and visit her behind a glass wall nowadays, and it's not like it used to be, just to get a piece of paper that should otherwise be available on the website, so that a citizen can comply with the requirements that the BZA is setting forward. And that's assuming that we set aside whether it's even legal for the BZA to require that form to accept the appeal. We're talking about two different things: accepting the appeal and beginning to process the appeal. I don't think that I should be standing here in front of you today without timely submission of that form. But the question is, does that form is that form required to indicate an appellant's intent to appeal? So, if y'all don't mind, do y'all have any questions, or can we take questions? Can we do questions right now? Sorry, I didn't want to just go into the next
I mean,
thing.
if somebody has questions, I think it'd be fine, but I
Okay.
don't have any at the moment.
Okay.
Is your next comments regarding, again, the timeliness issue?
Yes, ma'am.
Okay.
Yep. So if y'all don't have any questions, I'd like to ask some questions of Ms. Parker, if you don't mind.
I'm not sure that's appropriate.
I'm calling her as the secretary of the BZA just to verify some, as a witness, yes, ma'am.
Okay, that's an unusual process. What do I need to do, Ms. Spalding?
Well, I mean, let me.
If you'll excuse me for a moment, if we already have extensive emails between Ms. Parker and Mr. Weiner, I'm not sure, since she is the secretary and taking minutes, I don't know if she can state anything aside from what's already in her emails. I'll ask you guys to rule on.
Well, I've certainly read all the emails. Do you have questions outside of that?
I do. I mean, I'm not looking to stand here and go through the whole laundry list of establishing what's already in the record.
I appreciate that. That took me a long time.
You know.
I think the record speaks for itself in her emails. Anything, if we were closed on Sunday, they didn't have any correspondence or telephone correspondence. I think we're limited to the emails that's already in the record. I don't know that she's had any conversations with.
Well, I would suggest then that you raise whatever questions that you have as
I'll
part of
just-
your presentation, and
I'll
if
just
we
make
want to
them as-
follow up, we will.
Yeah, I'll just make them as points, and then if we need to go from there, we can.
That would be
Okay.
appropriate.
So, you know, there's a few specific things that are required to initiate the appeal per state code. You have the person who's filing the appeal has to be identified. The decision that's being appealed has to be identified. And there has to be a fee paid, right? And so, you know, the questions that I wanted to ask Ms. Parker in her role as the BZA secretary were just to verify that she understood who was appealing, what decision was being appealed, and just go through those requirements as they're laid out in the state code. So if counsel for the county is willing to stipulate that the requirements in state code were met, then we can move on.
Well, we're going to move on anyway, but.
Okay, sounds good, sounds good.
But we all
okay.
can read the documentation.
you can
and-
read
and
it, yeah.
Make our
Yeah,
own conclusions.
so there is one other point that I want to raise that I was going to walk through with Ms. Parker, but the record reflects, this was surprising to me. The record reflects the communication that her and I had on or about April 5th, 6th, and in the days following that. It reflects her title as Director of Customer Service. And I don't believe that the Director of Customer Service for Community Development has any involvement in the BZA proceedings, right? And I think that language, and she can't speak to this, but just stepping through what I would have said if we've gone through the questions I had. I think that language referring to her as the Director of Customer Service in the record is an intentional effort by the county to misconstrue the communications that I had with her when I was communicating with who I thought was the BZA secretary. Okay, so I think it's important, to highlight that, because I think that the county is trying to misconstrue an email that I sent to the BZA secretary as an email that was sent to the Director of Customer Service, because I know full well that I don't need to file this appeal with the Director of Customer Service for Community Development. I need to file it with the BZA secretary, per the written notice that I received on March 6th.
Well, I think we're all aware that Ms. Parker is our secretary, so we can leave that,
Yeah, so.
leave that point alone.
Yeah, and I understand. I just, it struck, as I was reviewing the record that the county provided, it struck me that, as I'm reading that, I read that as, I know what she is to y'all, she's also something else. And that distinction, I think, is really important in the situation, because we, if I had sent that email to the director, if she was two different people serving those roles, if I sent the email that Sunday with the information about the appeal to the Director of Customer Service, not to the Secretary of the BZA, that would not have been a timely filing. So I think it's important to distinguish that. So let me just look through here real quick. I'm kind of changing this up since we're not talking to her directly. So I'll also point out real quick that if you look at the notice of violation, it specifically says that notice has to be delivered to the BZA secretary, which directly conflicts with state code. State code says the zoning administrator. So the county's own forms present additional conflicting information, or the form provided presents conflicting information. Now, that being said, Monday the 6th, when I received an email back from Ms. Parker, it also included the then zoning administrator. I assume Mr. Cash would have been referred to as the zoning administrator at the time. He was CC'd in on that email, so as of the next business day, he was aware of the appeal, whether that email was sent to him. But you know that fills. Hope that addresses both of those issues in there. I do have a few. If you can just give me one more second, I'm sorry. I'll just skip all these questions because it's all on the record. You can, you can read the things that I was going to go through, or I can.
We read them all.
Yeah, that's very clear, and I appreciate y'all's diligence. And I'll also say I appreciate y'all's time today. I know this is not y'all's day-to-day job, that everyone's taking time out of their day to be here, so I appreciate that.
All right, thank you.
So, thank you very much.
So we are up to, if I'm not lost my place here, are we up to rebuttals? Is that what we're up to?
Thank you. I'd like to, if you don't mind, to call J.M. Whalen, our POD administrator. Could you please take the witness chair? Thank you. You want to bring your binder with you? Thank you. Got to have that binder, right? We all love our binders. All right, Mr. Whalen. Would you turn to page 47 in your binder? It's like we're in class. Everybody's on the same page. All right, Mr. Whalen. We're on page 47?
47.
Yes, sir. Thank you.
Can I ask a question real quick?
Yes, sir.
Is there anything that's going to be presented from him that's not already in the packet?
He knows personal knowledge about when this was mailed.
Okay, thanks.
Yes, sir. Thank you. That's a great question. Mr. Whalen, page 47. Are you familiar with the first on page 46, the notice of voided POD?
Yes,
Did you send that?
yes,
Did you mail it?
yes,
Did you put it in the mail yourself?
yes.
Do you know what date you put it on in the mail?
March 6, 2026.
All right. And where did you put it in the mail at?
I had to do this a little later in the workday, so I used our in-office postage to get the postage set and took it right down the road to the post office that's off the courthouse here.
And were they unable to postmark it for you? Did you?
I got there probably around 4:30, and I just asked them to make sure that it went out today, and the worker at the post office took it and assured me that it would go out today.
Thank you. I have nothing further of you, and if you can take your seat, and I will finish my rebuttal. Thank you for your time. I want to touch on a couple points Mr. Weiner mentioned. You'll notice in your record, if you look at page 50, Ms. Parker emails Mr. Weiner first thing in the morning, Monday morning. And she says, attached is the BZA appeal application and disclosure affidavit. Once complete, please return for application and payment processing. Ms. Parker is not an attorney. She is not able to give legal advice. She cannot tell him anything about when he sent it in and whether or not it's approved. Mr. Wiener testified to Mr. Babbitt. When Mr. Babbitt asked him when he knew about the notice being voided, he said, "I knew on March 6th it was a bad way to start a weekend." He knew about it. He was familiar with the process. It is not required for the form to be on the website. If you look in section 10 or record 10, you can see Amherst County, Chesterfield County, Henrico County, and every other county in Virginia has a form that you have to fill out. Your own BZA bylaws require your form to be filled. It is not required by state law on where we're supposed to house the form. That's just up to us. Mr. Wiener waited to the last minute. Ms. Parker was very kind to send him the forms right away. He was familiar with this process as Ms. Worley had already sent him the LBBCA forms. Under the Dillon's rule, other counties, we cannot usurp statute, state statute, but under the Dillon's rule, and us and other counties can all have these forms that are required for the applicant to complete. And you can see that other counties say, if you do not complete this form, then it is not completed. Your application will not be accepted. I have nothing further.
All right, thank you. Mr. Wiener, I'll give you an extra minute if you need it as well.
I appreciate it.
Sorry, I did not see the red.
So let me just back up a little bit, okay? Did I wait till the last minute? I waited till the last minute. Is that when I had time to sit down and try to deal with that, being a father of 3 little humans, and a husband and a business owner in the county? Yeah, you know, could I have spent the weekend right after I got the notice, filing the appeal? I sure could have, but I also didn't expect to need a piece of paper that I couldn't get on a Sunday when the county's closed, when most other paperwork is available. And ultimately, I don't think that what other counties do is pertinent. I think that, you know, we're talking about state code and y'all's policies. Okay, so there's definitely a difference between filing the notice of appeal or intent to appeal, whatever the technical term is, which I think that email and the attached video sufficiently provides notice. That's different than Ms. Parker referring to processing the application, which is different than y'all considering the application, which is the language in your bylaws. I'll also touch on the postmark part of it real quick. You know, I'm just like all y'all, I'm a citizen in this county. Okay, if I drop a property tax payment in the mailbox at my house on a Friday afternoon, let's say it was Friday, March 6th, and it doesn't get postmarked till Monday the 9th. Well, whatever. I'm just using whatever dates, okay? But the postmark date matters, because if it's due on the 5th or the 6th and it's postmarked for the 9th, the treasurer is going to assess me late fees, right? That postmark matters. I don't want to stand here and split hairs over it. What I want to talk to y'all about is, you know, the merits of this case, which, you know, that's a whole other issue. You know, I feel like we're just splitting hairs over technicalities and, you know, not over the appellant's, intent to comply as best as possible with the resources that were provided by the BZA. You know, I can't tell you where I was that Monday morning when Ms. Parker sent that email back to me, but I guarantee you probably wasn't sitting on my sofa at home. You know, those of y'all, you know, for the folks that know me, I'm out and about all day long. I don't sit at a desk. You know, so it may take me a day or two to fill out a piece of paper. And I think in this case, it got missed and went to my junk folder. So things happen. We just have to decide what is actually required and whether, whether it was fully met or met close enough. So appreciate your time.
All right, thank you. So if the county's representative would like to give a closing statement, now is the right time.
Yes, sir, thank you. State law and county ordinance mandates that Big Daddies file their appeal within 30 days of the POD administrator's determination, the date of that the notice was issued. The POD administrator issued the notice on March 6th. The deadline was April 6th. Big Daddy's email on April 5th does not constitute the correct form that is required in your bylaws, just like every other county does. It was not proper filing. Big Daddy's attempted to file its appeal on April 9th, 3 days after the fact. Voorhees already has stated their circuit court has held that filing 3 days late is not timely filed. Since Big Daddy's did not timely file its decision, the POD administrator's determination voiding the POD is binding, and the board does not have jurisdiction to hear the substance of Big Daddy's appeal. Mr. Weiner states that timeliness is just splitting hairs and doesn't matter, it's just a technicality. Oh, yes, it does. That's what keeps order, and that's why we have procedures for things. He said he didn't have time, maybe because of little ones, to file on April 5th or 6th. Yet he had time to file 2 other appeals with the LBBCA on April 5th, as I showed you in the record. He said the email from Ms. Parker may have gone in his junk folder. I find that hard to believe when he received all her other emails. And Mr. Weiner operates Hosted Backbone, the internet service provider for most of Goochland County. He would know to check in his junk folder. Thank you.
All right, thank you. Mr. Weiner, would you like to make a closing statement?
So, first of all, I don't want to minimize policy and procedure. It's there for a reason. I agree it helps maintain order, okay? Life is not black and white, though, at the end of the day. And I think that what we're talking about right now highlights how much gray there is in the world that we live in and in our daily lives. So that's the ad lib part. Mr. Chairman, members of the board, thank you for hearing the evidence today. I believe that the evidence in your binders establishes several facts that are not genuinely in dispute. Those facts are established by the county's own record in this case, even with the gaps and the testimony presented today. First, the county received, the BZA secretary received my written notice that I intended to appeal the POD administrator's decision on April 5th. Second, there was never any confusion about what decision I was appealing or my intent to appeal it. Third, the county began processing that appeal. It acknowledged receipt of the filing fee, provided the board's application, continued communicating with me. Mr. Cash subsequently followed up with an email, and that's where we found out, that's where we caught on to the email in my junk folder with the with y'all's application. At no point, the evidence also establishes, by the county's own admission, that the board's appeal application was not provided until after I had already submitted my notice of appeal, which is what's required by statute. Once provided, it was completed and returned in a timely fashion. The county's position appears to elevate a procedural document over the undisputed facts. The evidence shows that the county had timely written notice of the appeal, knew exactly who was appealing, knew what decision was being appealed, and began processing the appeal. They requested additional paperwork. It was provided. I also want to be clear about one thing. As I've said a couple of times, I'm not asking the board to disregard its own procedures. As I said, once the application was provided, it was completed and returned in a timely fashion. Your authority is derived from the General Assembly. Accordingly, the board's bylaws should be interpreted and applied consistently with the Code of Virginia. If there is any tension between the two, the statutory requirements enacted by the General Assembly would govern. I respectfully submit that my timely written notice, the email that was sent, satisfied the filing requirements established by 15-2-2311 of State Code, and that your administrative procedures should not be interpreted to defeat that statutory right. Today's issue at this moment is not about the POD administrator's decision, whether it was correct or not. The issue right now is whether an email that was sent with the required information constituted timely notice of appeal. we would not be having this conversation right now about this if this particular form had been available on the county website or in any other way other than asking someone for it. For these reasons, I respectfully ask the board to find that this appeal was timely filed, that you have jurisdiction to hear the appeal, and allow this matter to proceed to a hearing on the merits. Appreciate it.
All right, thank you very much. The preliminary hearing is now concluded, and we were going to turn it back to the board for deliberations. And I think, Ms. Cook, I'm going to give you your opportunity to pick up wherever you left off. When I stopped you, sorry.
Thank you. I still do have the question. Couple, one, I'm trying to look at it through the lens of both parties, but the language that says notice of appeal form is available. The word mandatory is not there, but the BZA bylaws is where I believe I've heard is the mandatory requirement. Are the BZA bylaws visible to the public? Is that something? Yeah.
I am not aware if they're available or not. I don't know if, Madam Secretary, if you're aware. I'm not aware. I don't know the answer, sorry. Even if they're not available, it's very clear in the notice of voided POD where to get the form. And Mr. Weiner had ample time to call and request it and find out.
Understood. It's just, as I'm reading this, again, trying to be objective, it says notice of appeal form is available. It doesn't say mandatory notice of appeal form, so to me it leaves a little ambiguity on, because it seems to me the merits of what we're talking about right now is what was submitted, did it suffice and meet our BZA bylaws? However, if the appellant's not aware of those bylaws, then I don't know.
I think I understand what you're saying, and that's a great point. However, it says on the form where it's available. If it had been available in more than one place, it would have said so. So the fact that it lists only one place that's available stays, that's where you get it from.
It's not where you get it as much as that the form is mandatory versus if the citizen is looking at
Yes.
the statute and the required information.
And that's why Ms. Parker very quickly sent him the forms and said, please fill out these forms. And he was familiar with the forms. He'd done these appeals before and knew that there had to be a form.
One other question, and I
Yes.
think you said this, I want to make sure I was clear.
Sure.
Ms. Parker, in her role, I noticed as she responded, she didn't give him a deadline for the form to be received, for it to be considered in her, when she sent him the form.
Right.
Is that?
That's because
what-
she's not an attorney
Okay.
and is not able to give legal advice.
Okay, that's what I thought she said. Thank
So,
you.
yes, that's a great question. Thank you. Any others?
Yeah, is the only way that an appellant is notified of the decision on the POD is by certified mail?
I believe it's also shown in EnerGov. The POD administrator would be able to speak to that. Because Mr. Weiner did testify, and it answered Mr. Babbitt and said, yeah, I knew on March 6th, not a great way to start my weekend. So he knew before he even got it on, I think he signed
But that's
something.
him, that's the appellant going and logging in and finding that himself, correct?
Do they send emails?
It's not an intergov.
I'm sorry, is it in emails, do they send, that something's updated on EnerGov?
Did you get that email on March 6th?
I did.
So that's how you knew. So you, I'm going to state this very clear. It's okay for the county to email and send something as a notification, but not okay for a citizen to email all of the applicable things that are within an application. So we are splitting hairs on electronic communications that suffice for both. He knew March 6th from the email, and there was written notification that was in the mail coming to him.
That's a great question. Let me
Perfect.
clarify, because that's not exactly correct. We send emails as a courtesy. That is not our procedure. That's only just to let people know the way our EnerGov works, it just automatically updates. But our procedure is we have to send it by certified mail, and that's what we rely on.
That's great, because that even now sheds light on that the letter wasn't received until March 13th.
Yes.
So,
But that,
so we've lost, the appeal it now has lost, if they didn't go on their own
Yes.
and get that email, if you didn't send the electronic communications, now, really the only thing that needs to happen is that letter needs to be sent to the appellant, to their address, to officially notify them by a delivered mail that is now certified mail and tracked that this is happening. Someone that doesn't have a computer at home, an elderly person at this, they're gonna wait until they get that letter in the mail. Would that be a
And-
correct statement?
and that's why the Voorhees court was very clear in what the court held, that they worked off the date of the approval of the grading, not when the person, the appellant, received their certified return copy. The court was very clear in that and worked off the approval determination until the 30 days later, not when the appellant got their certified mail.
I believe in the Voorhees case too, it's, as far as case law, it's not bringing into the consideration the differences in this case, that there was an email sent that was, particularly from the appellant, it sounds like mostly understood that that was accepted until later on in the communications.
Well, that was the whole point of Ms. Parker sending the email to him with the form saying to please to complete. And this isn't
Yeah.
something that, if this had been a citizen who had never done this before, wasn't familiar with the process, I can understand.
Well, I don't think that's a fair statement for a citizen in any fashion.
I
mean,
think-
we can't take that on a consideration of, well,
Yes,
this
I understand.
person's done it before or not. I think
I
it's
agree.
more of a procedural thing on how I think this will help the county grow all which ways, and maybe even changing some things for the better to make this to where,
And we did follow procedure, and that was why Ms. Parker her wonderful customer service of first thing Monday morning sent the forms. And those forms could have been sent the week before or the week before if asked. That is the procedure that we have, and that does need to be followed.
thank you very much.
Thank you. Lots of good questions.
Can I add on to that a little bit?
No. Sorry. Just because it's back to the board now.
I understand.
And so, I'm going to try and frame this I'm not a lawyer. And so, I've certainly read the Voorhees case, which very narrowly defines that you have to stay within the 30 days, otherwise you're out of your jurisdiction. Done. So we're not about how are we going to extend 30 days. The question is, when does the 30 days begin? Does it begin on one day or a different day? And then reading 15.2, 2311, the applicant or appellant pointed out again, and I think Mr. Rosenberg as well, that the language specifically mentions the receipt of the information by mail. And it's very clear that that's in there. And so I did a little research. And what I found was an interesting case. And maybe you can comment on Callaway versus City of Chesapeake 2023. The Court of Appeals held that 15.2-2311 notice requirements are mandatory, which of course we've already said. They're not optional. The court emphasized that a valid enforcement action depends on compliance with the statutory notice provisions, and it noted that the 30-day BZA appeal period begins only after valid statutory notice is provided, and that included the mail requirements. And so they're in somewhat disagreement with Voorhees, if you will. This finding was, like Voorhees was 2006 or 7, somewhere in there, maybe 2009. So I'm not a lawyer, I don't know all the dates, but this one is 2023, so it's more recent from the Virginia Court of Appeals. And so, I think it follows normal logic. If you just simply read the statute, it says this is when it, and so if you take that sort of stance, and I'm inclined to do so, then your 30 days doesn't actually begin until the letter arrives and they sign for the letter, or at least it arrives. Because to do so would imply that if the appellant was traveling in Europe and didn't get any notifications, didn't get any mail, that he might arrive back home finding that the time has simply expired in a decision that he didn't even know about. And so I'm fairly certain that's what the legislature is trying to avoid, so that people actually have notice of these sort of things. And so I'm inclined to think that the time actually started on March 13. But that's my own opinion, and I'm not sure how that sits with the rest of the board. And I'm happy to hear what you guys think about that, or whatever you want to talk about.
As long, I think we talked about the when, I'm probably a little bit more on the how, because of did the appellant satisfy the information and financial fee required on the 5th, which would have been inside of even the March 6th date. So to me, I think we have an opportunity to be clearer that the form is mandatory versus an email. And I understand why. I would appreciate a form just for consistency of information being communicated. But if I'm looking at it through the lens, the how piece, I think the county has the opportunity to maybe be a little clearer that it is a mandatory form and that this would not be considered until the form is received. So you're talking when, I'm talking how. So yeah.
Okay. You gentlemen have a thought down on that end?
Well, I think I have a tendency to agree with you in reading 15.2-2311. And again, I'm not an attorney by any stretch of the imagination, nor would I want to be. But when a statement says you have to do this and that means it has to be both. And so I'm troubled by that. I am heartened to hear that it was sent by certified mail on the same day it was issued. So that does satisfy my concerns about the dichotomy of the two dates. I'll disagree with you relative to the interpretation, if I might, respectfully, because 2311 states that the written order is sent. It doesn't say it's received. And I think that's specifically because that's the only thing that is controllable. The county can't control when you go to the post office and pick it up. It only can control when we sent it to you. So yeah, there's depends on who you talk to in the post office. It's either a 3-day or a 15-day delay in getting mail posted, but that's that's the way life is. I do appreciate that additional information. Thank you.
Thank you, understood. Mr. Boatright.
The only thing I'm stuck on is we have bylaws for our group, and no appeal shall be considered by the board unless it's made on the form required. And that's kind of where I'm stuck, because we've got something standing, and I don't want to stray from that.
Understood. All right. Any other comments on this end? Otherwise, if somebody would have a motion, I've got some proposed motions. If somebody would like to make one, I'll hand you the slip. You already got it. Never mind.
I'll jump in.
All right, Ms. Cook.
All right. I motion that the appeal AP-2026-000005 was timely filed, and the basis for my motion is that I feel that information, the required information and the financial fee was provided on the 5th, and that the bylaws, and I agree with Mr. Boatright, though important, if they're not visible to the appellant, I'm not sure that the process was very clear that that was a mandatory form.
Okay. Thank you. Is there a second for that motion?
I'll second that.
Mr. McDonald. All right, we have a motion and a second, and I guess we'll call the motion. Would you, Ms. Parker?
Sure. Mr. Boatright?
No.
Mr. Rosenberg?
Nay.
Ms. Cook?
Aye.
Mr. McDonald?
Aye.
Mr. Babbitt?
Aye. This is happening a lot lately.
The motion, let's see, the motion that the appeal AP 2026-5 was timely filed, passes on a 3-2 vote.
Okay. So. We're now going to move forward to hear the actual appeal, and hopefully, Not- not-
I actually would like to request a continuance, and I have some prepared remarks to read to y'all justifying it, if you don't mind.
I'm not sure that's permitted, but
I'm sorry, I'm not sure when I'm supposed to, you know,
This is coming late into the hearing, it's already taken place, everything has been noticed, and there's no need for the appeal, as there's been ample time to prepare, everything has been provided. There's no need for this, I ask that you just
see,
okay. So maybe let's start with reading the, the actual appeal, and then we'll kind of go from there.
Sure. AP 2026-5, application for appeal filed by Big Daddy's Oilville Office Land Holding Corporation, LLC, with the Goochland County Board of Zoning Appeals. The documents submitted purport to appeal the notice voiding the plan of development, POD 2024-19, for 1164 Tri-County Drive on tax map number 45190240. Issues to be determined include whether the appropriate materials were timely filed to submit an appeal and voiding the POD pursuant to County Code 15326.
Okay, thank you. And on the idea of a continuance, that we never had that occur before, how does that process move forward if we're going to consider that?
well, can I explain why first, and then we can,
Once we know the process, so
okay, understood.
hold that thought.
I'm not certain that we can split this hearing into two parts. The two issues that we can continue one part and not the other. We would have had to have probably continued for both issues.
Understood. Ms.
You
Baldwin,
actually have no provision in your bylaws that discuss a continuance, so I think you do have to look at this from a practical standpoint. Mr. Weiner has suggested that he wants a continuance for this portion of it. However, potentially he should have brought that argument at the very beginning before this actually started. And on some level, I won't make that remark. I think because you have no procedural way to do that, you may want to hear Mr. Weiner's reason, but I don't know that you have a methodology by which to do this. And you may have to consider Ms. Hightaffer's remark that it should have been done at the very beginning so that both of these procedures were heard together.
Understood. So let's do this, Mr. Weiner, when we're going to go through the hearing as planned, and when you get to the part where you have information that you don't have ready, if you would just tell us what that is, we can decide for ourselves whether we would like to continue to a future date to get that information rather than stop this process right in the middle like this.
So, Mr. Babbitt, the.
Approach the mic, please.
There's information, that the county has information that is not reflected in the record, that I requested via FOIA, and I'm not trying to litigate the FOIA portion of it right now. I requested via FOIA back in March. I did not receive a copy of the record till last Monday. After receiving a copy of it, I asked for the additional information that I believe exists. I brought up the idea of a continuance, that was shot down. And so, you know, that's why I would request a continuance. It's because I haven't been able to prepare, because there's information that I have not been able to review. I was prepared to argue the timeliness issue, because that's much more cut and dry. But I strongly believe that there are county records that have been withheld without it, that were properly requested, and then withheld multiple times.
Okay, understood. You can have a seat then.
Thanks.
So I'm not sure it's necessary to to respond, but so I would still prefer that we proceed on with the hearing, and if there's specific things during your presentation that you feel are apply to whatever it is that you're missing or couldn't prepare for, you can just comment on that. And again, we as a board can decide if that's germane to our decision. And then we can have a hearing at a different date, or we can move on that way. I think that's probably, does that seem reasonable?
It does, Mr. Chair.
Okay, so let's just move forward, and then you can talk about that in your time. So, with the county's representative, please come forward for your opening remarks.
Yes, sir, thank you. As mentioned earlier, on June 3rd, 2025, Big Daddy's received an approved POD, which also means Plan of Development or Site Plan. The approved POD did not show a 6-foot-high, 100-foot-long retaining wall. The county ordinance requires the retaining wall to be shown on an approved POD. In December of 2025, during a routine inspection, county staff observed a fully constructed retaining wall. County Ordinance Section 15-326 states a deviation from an approved POD without the POD administrator's written approval shall be voided. The POD administrator never provided his written approval to the deviation. The POD administrator voided the POD on March 6, 2026. The board must only decide whether the POD administrator's determination was correct. The POD administrator's determination to void the POD was in fact correct, as we will show in our presentation. Mr. Winter?
Mr. Chairman, members of the board, before I get into the merits, I want to briefly note for the record that I respectfully disagree with the board's decision to proceed without a continuance right now. I continue to believe that additional time would provide the board, would provide me as the appellant the appropriate information to prepare. The information that has been withheld is necessary to prepare. And so I'm left in a position where I have to go on a fishing expedition in front of y'all to try and fill in blanks about records and documents that were not produced. That being said, I'll do the best I can.
Thank you.
The question before y'all today is whether or not the POD administrators to void the approved POD was supported by the facts, consistent with the applicable ordinances, and reached through a fair administrative process. As the county says, they became aware of this retaining wall in December of 2025, once I was already in the process of working through the building permit process with the county. It started out as a 3-foot retaining wall, which does not require a building permit, okay? I then decided to go to 6 foot. Why? Because the grade on the site was deceiving. And, you know, it was not a big change in my head. I've been through the process of securing a permit for a retaining wall. I know I need one when it's over 3 foot tall. How do I know that? Because when I put a pool in at my house during COVID, I found out that I need a separate permit for the retaining wall, and it's not part of the building permit for the structure or anything else. So I knew what was required, okay? At least I knew what the county required of me in 2021 to put a retaining wall in holding a pool back, okay? The evidence will show that that between December and March, I tried to work with county staff, the building official, to resolve issues about the retaining wall permit. Most importantly, the evidence clearly shows that the POD administrator told me not to submit a revised POD until I sorted out things with the building official first. Okay, so in December, when he became aware of this, he didn't void the POD like he has to do. And that's the county's position. He didn't have a choice. He waited 4 months, 3 or 4 months to void the POD while I tried to sort out the issues with the building official. So the county, on one hand, claims that the POD administrator had no discretion, and yet his actions directly contradict that. The evidence also shows that before voting the POD administrator never withdrew the written instructions he provided me to wait on submitting a new POD. And for the record, I didn't even know the retaining wall needed to be on the POD in the first place. Okay, if someone had said put it on there, I would have put it on there. Plans change. Okay, life happens. So, you know, at the end of the day, you have to comply. I understand that. And what is required to comply varies. I have no problem with that. What I have a problem with is being told, do this. Okay, oh no, I'm not gonna tell you not to do that. Now do this instead. The evidence also shows that in the process leading to the decision to avoid the POD, including discussions, well, the absence of it, the evidence that I have not been provided, shows that in the process leading to the decision to avoid the POD, including any other records that the county may have, those are withheld. And so the POD administrator then got to the point of taking this extraordinary step. This is the first time a POD has been voided in Goochland County. I'm not sure if y'all know that. The action taken by the POD administrator is literally unprecedented. And the county sits here and wants to say, Mr. Weiner, we're not going to give you anything that we don't think you should have, even though you legally request these documents. So at the conclusion of the evidence, I'm going to respectfully request that y'all reverse the POD administrator's decision on the basis that he provided written instructions and written guidance to hold off on submitting a revised POD, which, based on the record, appears to be an option. And that if I had been told to submit a revised POD or to submit a new POD in December 2025, I would have done that. But that's not what I was told to do. So ultimately what this boils down to for me is, you know, I'm being penalized for not following the instructions that I was given. And I'm sure we'll go into that more, so thank you.
All right, thank you. Would the county's representative like to provide their presentation and testimony, please?
The POD administrator respectfully requests that the BZA uphold the POD's administrator's determination. Specifically, Big Daddy's property is zoned industrial, general M2, and its use of the property requires a POD to comply with the county ordinance, section 15-34. If you look at, with me, page 1, actually do page 17. You'll notice under site statistics, it talks about the proposed use. And under this proposed use, which falls under record 10, we go to record 10, page 142, this requires a POD under section 272. And then if you go with me to page 144, this is what requires the plan of development. Section A, 5, and B7. B7 states location, type, size, and height of fencing, retaining walls, and walls. That's on page 145. On June 3rd, 2025, Big Daddy's received an approved POD for its property, which we've already discussed. And then Big Daddy's approved POD does not show a retaining wall. Here's the approved POD. And you can see on it, it has lots of things. An existing wood fence. It has drainage. It has land disturbance. There's no retaining wall on it. If you go to page 32 in your binder, this is the 100-foot wall that was constructed and noticed in December by staff. 6 feet tall and 100 feet long. And so what happened was he's required to have a building permit for this, which he filed. And this is the site plan that he submitted for his building permit. And you can see in green, see if I can highlight it, up here is the retaining wall at the back of his property. Code section 15-326, if you go to page 149, states, and I'm just going to hit the highlights of what is pertinent to this case. It's unlawful for any person to construct a structure for which a plan of development is required except in accordance with an approved plan of development. So this structure was not on the approved plan of development. Deviation from an approved plan of development without written approval of the Director of Community Development shall void the plan and require the submission of a new plan of development for approval. Here's the the notice of voided POD. And you can see that the plan of development administrator cites the same code section. Go with me to page 44. These are the emails between the plan of administrator and Mr. Weiner. If we start chronologically, we can go to page 45. And it says, actually, I'll just call Mr. Whalen. We'll have you go through them. Bring your binder with me. Mr. Whalen, if you would turn to page 45 in your binder. Can you please read for me what you wrote in response to Mr. Weiner's email?
Which email?
It's the one on page 45 at the top where you say, "Good morning, Evan."
Okay. After speaking with building, I'm going to let them work with you on the wall before we address.
Actually,
POD.
hold on.
Yep.
I'm backwards. Oh, that's right. Sorry, I'm
Okay.
trying to think if I'm chronological. You're right, keep going.
I do not see any retaining wall on the approved site plans, so we will need to modify the site plans to show this and any other changes that occurred during the construction process, and review the site plans formally once we know there won't be any modifications to the retaining wall.
Now, Mr. Weiner had said in his opening that he didn't know the retaining wall needed to be on the POD. But you stated in your email that it did need to be on the POD. Is that correct?
Yes.
All right, turn with me on page 44, your second email to Mr. Weiner. Can you read for me that first paragraph?
Is this the email that is dated February 2nd, 11:41 a.m.?
That's correct.
Okay. I understand your concern for time, Evan, but you must understand that the structure was not on the approved POD in the first place and should not have been constructed. This technically puts you in a place where you're in violation of the code regarding your POD.
Okay, and this is the same code section that you referenced in your notice voiding the POD.
Yes.
Okay. Can you read for me the second paragraph?
Staff worked with you throughout this process from start to finish, and I know you're aware that the modifications to the plan should be communicated to the county so we can ensure there are no detrimental consequences to your property or surrounding properties. In the spirit of working together to correct the issue, I would advise that you comply with the building and update your site plans to include the location of the structure and include the details for the structure in the plans, as well as including the documentation from the building permit. If you would like to resubmit for formal review, that's fine. Just understand that if building requires modifications, those will need to be demonstrated on the plan of development. Let me know what you would like to do, and I'll work with you from there.
So you advised him to update his site plan to include the location of the structure, the retaining wall. Is that correct?
Yes.
You told him to let you know what he wanted to do. Is that correct?
Yes.
Okay. Were you trying to save, you mentioned time in here several times, his concern for time. Were you trying to save Mr. Weiner time?
Yes.
Approximately how much time are we talking about that you're trying to save him?
A formal review for plan of development is approximately 30 days. So at minimum 30 days. If there was a resubmittal required, because these PODs are reviewed by many departments in county and VDOT potentially if there was changes to access, it could be more.
So let's go back to the bottom of the page, Mr. Wiener's email on February 2nd at 11:08, on the same page, page 44. And Mr. Wiener asked if revising the POD would hold up issuance of a building permit. Would have it, yes or no?
Typically, but this situation with this permit is a little different
Why?
than our typical, because the structure was built without a permit, so we're kind of out of order.
What happens when you're out of order? Do you have a process for that when something's already been built?
There's not a SOP,
Which means what?
a standard operating practice,
So what do you do when that happens?
what the ordinance prescribes,
What ordinance?
the Goochland County ordinance.
The 326?
Yes, ma'am.
Okay. All right, turn with me on page 43. Mr. Wiener's February 2nd, 11:49 email. What does he say? In the first paragraph, first two lines.
JM, I understand that I need to resubmit the POD and am completely willing to do so.
So he understood he needed to submit a new POD.
Yes.
Okay, and he was willing to do so. All right, your next email, February 2nd, 12:05. Can you read for me? You put in here a response to Mr. Wiener. Can you read the sentence starting with yes?
Yes. Yes, I would show everything that is being constructed on the site plans, and please submit a revised site plan under your POD permit once that is ready for review alongside a paper copy.
So again, you're asking him to submit a revised POD. Is that correct?
Yes.
All right, flip to page 42. Your email at the bottom, dated February 2nd, 12:14. What do you tell him? Mr. Wiener, what do you tell him?
Yes, Evan, it is a new structure being built on the lot that needs to be included in the site plans.
Again, he needed to include this on his site plans, the retaining wall. Is that correct?
Yes.
Is there anywhere in your 4 emails where you tell him to hold off on submitting a
No.
revised POD? Are there any other records or any other emails between you and Mr. Wiener that are not included in this packet?
No.
All right. Go up to his email on February 2nd, 12:51 p.m. Read that last line, starting with once.
Once I get Adam's comments, we'll figure out if it will be 1 6-foot tall wall or 2 3-foot tall walls, AKA permit for them or not.
So is Mr. Wiener changing the size and dimensions of the retaining wall here? Is that what he's suggesting?
That is how I interpret it.
Okay. All right, I have nothing further for you. You can step down. So under the BZA authority, it's there. Under code section 15.2-23091, it states, the BZA has to hear and decide appeals from any order, requirement, decision, or determination made by an administrative officer in the administration or enforcement of this article, or of any ordinance adopted pursuant thereto. It then states the decision on such appeal shall be based on the board's judgment of whether the administrative officer was correct. There is a presumption that the administrator's determination was correct. And at the hearing, the administrative officer shall explain the basis for his determination, which he just did, and the appellant, Mr. Wiener, has the burden to rebut that presumption. That is all I have. I will let Mr. Wiener.
Are there any questions from the board for the county? Okay. Would the appellant like to come forward and give your presentation, please?
Do y'all mind a 30-second bio break first? I'm sorry. Say what?
Yeah, maybe we'll have a short recess. Yes,
Yeah,
we will do
thank
that for you.
Thank you so much.
Thank you. proceed on. If you'd like to start, Mr. Weiner, I'm sorry. Okay, why not? Let's let's give you a little extra time.
All right, Mr. Whalen, we're going to go back to page 42. Now, the code says, you said that this was done backwards, and so you followed the code, section 15-326. Is that correct?
Yes.
So you didn't void the POD right away. Why was that?
In an effort to provide customer service to our citizens, wanted to give him an opportunity to make a correction to the plans.
Okay. So the last email that you sent Mr. Weiner on page 42 is February 2nd at 12:51 p.m. Is that correct?
Yes.
No more emails were sent. Is that correct?
Yes.
No more correspondence between you and Mr. Weiner until you voided the POD on March 6th. Is that correct?
Yes.
What happened from the emails on March 2nd until March 6th that prompted you to void the POD?
For clarification, do you mean from February 2nd? to
Yes,
March
sorry,
6th?
February
Okay.
2nd to March 6th. Yes, thank you.
During that time period, I talked to the building official, Casey Littlefield, and other building inspectors that were working with Mr. Weiner to address the retaining wall in the property. I had spoke with them just to make sure that things were moving and we were getting the building permit towards an approvable state. So that way if we got to that point, when the wall was put onto the plan of development, we would have everything we need for that to be good with the building department. It would be approvable. So we have a structure that would be approvable on the plan of development plans, so we wouldn't have to go through the time sink of multiple reviews to get it to that point.
And you mentioned earlier, a full cycle could be how long?
30 days.
30 days. Are there many people that have to review this POD process? Is that correct?
Yes, formal review is typically building department, environmental department, planning and zoning, fire, transportation, VDOT, any state agencies that are required to review certain things. There's many parties that look at these.
So if this wall had not already been constructed, how would the process have played out? What's the normal? You said typical process. What's the typical process?
If the developer wanted to put a retaining wall there, that's fine. He would just need to show it in the plans and what impacts it would have on the site and what would be needed to construct it, details for the retaining wall so we would know what it's constructed of, make sure that it meets any proffers or conditions for the property. Basically, we just ask for for whoever it is to provide as much detail as possible relating to the structure, since it's required by code that we have that information on the plans.
But this didn't happen as a typical process because the structure was already completed. Is that correct?
Correct.
Why haven't you ever voided a POD before? Or have you voided one before?
I have never voided a POD, and in my research for the county, we have never voided a POD.
Why haven't you ever voided a POD before?
Because we try to provide very good customer service here at the county. I understand the work that goes into having these plans created. I put a lot of time in myself reviewing and administrating them. And we know that the applicants put a lot of time and effort and money too. So my goal is to help them get to the point where they can accomplish their goal. So I would never choose the nuclear option of voiding a POD when there would be a path forward to fix it.
So what prompted you to finally make that decision where you were finally saying, I'm going to issue this now?
It came during that period between February 2nd and March 6th before I issued the formal notice. From multiple conversations with the building official and his employees that were working with Evan to try to work on the retaining wall building permit. They got to a point where they concluded that there was no forward movement happening, and they decided to issue a notice of violation and stop work order for the wall because they were not able to make forward progress in getting it towards approval.
What do you mean by forward progress?
They were working with Evan to make sure that they had what they needed to get a building permit approved for the retaining wall. And they determined that those conversations weren't going anywhere and that they decided to issue a stop work and a notice of violation.
All right. Okay, I have nothing further. Thank you.
Absolutely.
In your communications to the building department, Adam, and who you spoke to, what were those communications all face-to-face and verbal, or were any of those through phone, text, email?
Most of the conversation was in person.
In person.
Conversations, yes, sir.
Okay, thank you.
I have one quick question for you. With the voiding of a site plan, what happens to the site now that you've got a building and a wall, and what is the process going forward? Can they utilize anything, or do they start from scratch? They make a new plan? What is the process going forward?
So the approved plan of development, I guess as Tiffany pointed out, the proposed use by Mr. Weiner was something that is allowed in the M2. Now, things that are related to the commercial or industrial business, the structures, the laydown areas, the fencing, all those things, those still need to they need an approved POD in order for you to operate that. So when you do not have an approved POD, you're not able to operate the business out of that site. You would need to come back and reapply for a new one. And you would go through the formal review process, formal application process, as if you were just coming before us again.
So does the county padlock the site? What happens?
So he's not allowed to operate based on, there is no more approved POD. So if he does choose to operate out of the site, then he would be in violation of the ordinance. So the county can pursue code enforcement based on that.
Understood. Okay.
I would just like to say, the goal is to not do that. We want to work with our citizens.
Yeah, I understood that.
Yep.
Thank you.
Anything else?
Okay. Any other questions for the county now that I'm back up?
Thank
Okay.
you. Thank you,
We'll
Mr.
move forward again.
I'm done. Thank
Thank you for that extra information. So, Mr. Weiner?
All right. You mind JM instead of Mr. Whalen?
Yes, sir.
Okay, cool. This site, I think it's fair to say that there have been a lot of challenges with this site. Is that a fair statement? In terms of what I've been trying to do with it in the past 2 years?
I think that maybe you've had some challenges trying to get the process correct, but I think from the county standpoint, the use is straightforward and the process to get you there is straightforward.
Okay, so when you void a POD, most sites probably don't have, let me switch this around. Do sites typically have multiple PODs?
They can.
Okay, so if you void a POD, but there was a previously approved one, what would happen to that previously approved POD?
Well, the void only speaks to the one that's referenced. So the one you applied for would be voided.
Okay.
But the PODs will supersede the existing ones.
Well, what you just said is contradictory, I think. This site had a POD from 2014, 2018, something like that, right?
Yeah, it's an older one, yes.
Okay. So does that POD not exist anymore from an approval standpoint in your view, or would the conditions and what was approved in that POD from 2018 or whenever be back in effect now?
The plan of development that was approved, that we're speaking of towards yours, would encompass the whole site, and that was what the proposed new use is, and that's what it was approved for. So once that is removed, there is not another POD that's active on the site.
So what you're saying is that when someone applies and receives a new POD, any old PODs are basically as null and void as where we may or may not be right now. Is that your interpretation or your understanding?
Yeah, you're changing the proposed use for the parcel or the lot. So, laws change with the times. If that POD, if your POD, say, were to be amended, you would have to comply with the current laws. So if we're revoking and starting over again, you just need to meet what's new.
Okay, so if a site has, in this case, we have a site that had an approved POD for a contractor's equipment, storage yard, or rental of equipment commonly used by contractors prior to me purchasing it and prior to me submitting a new POD. So the use is not changing. So what happened to that old POD? I mean, I feel like you're dancing around it and you're not answering. I have a point. I'm just trying to get a straight answer on the topic.
Yes, but if you could form your question clearly so that the witness can answer one question at a time.
Okay.
The board could instruct Mr. Weaver.
No problem with what she said.
Okay, you understood that.
I understood that.
I was getting there, very close.
Yeah, sorry. I hear you say that if the use changes, the old POD wouldn't be valid anymore. But in this case, the use didn't change. So what's up with that old POD?
I guess on,
Again,
Yeah.
sorry to interject again, I'm not sure the relevance of this as
That's what I was
Big
gonna
Daddy's
say.
has operated on the site continually without any enforcement taken against it.
I would agree. It didn't, I think I understand that the administrators repeated a couple times now that the previous POD is no longer valid.
Sure.
And
So
I don't know
yeah,
why you keep asking the same question over.
what I'm getting at is just trying to understand the process and what happens, because I think that I think that what's happened speaks to there's a lot of questions and unanswered after this happens. So
Is that a question for Mr.
I'm sorry,
Whalen?
I was statement. I apologize. So Mr. Whalen, if from an enforcement standpoint, okay, if I have a parcel and I build a new storage shed, let's say it's 2,000 square feet on it, okay, what's going to happen to the approved POD on that site?
I'm sorry, I don't understand the relevance of this. These are hypothetical questions. If we could stick to this particular appeal and this POD that was void.
I agree.
Sorry, I'm on a bit of a fishing expedition because, there's none of the deliberative material that the POD administrator relied on prior to, or there are omissions in the information that I have about the deliberative material that the POD administrator relied on before voiding the POD. So
Sorry, but he's already answered why he voided the POD and
Sure,
how he got to that
I understand. I'm
conclusion.
just trying to, to your point, Mr. Babbitt, about the information I don't have. I'm trying to fill in gaps, and I'm trying to find out if there's any other information. I'm trying to find out what other information is out there that the county has been unwilling to provide.
I think he's
so I can
already
form my questions.
responded to that question as well and said there was no other
Well,
information.
no, he said, when Mr. McDonald asked him, he said, Mr. McDonald asked him if it was in person via text or emails or on the phone, and Mr. Whalen's response was not definitive. It was in general. Mostly, yeah. So,
I think maybe to help Mr. Weaver, if I could help him, and if you could ask a direct question, if there are any other records that he relied upon, that would solve this whole entire problem.
Yes.
You simply ask him a very direct question of the information he is trying to fish for, where we have already said there are no other records, but if he could ask that.
I would agree if you could keep your fishing to questions
sure,
instead of
understand.
comments.
Okay, so we'll just move on entirely.
Okay.
So, Mr. Whalen, have you been out there to see this in person?
not in many months.
Okay, but you did go out early, when it was covered in snow earlier this year at some point, I would assume?
I don't have an exact date, but yes.
Okay. And I know you're not an expert in building code, if I say to you that a building permit is not required for a 3-foot tall retaining wall, would you believe me and accept that as true?
I think that-
Outside the POD administrator's expertise.
Right.
There's a follow-up question.
If he would like to ask the POD administrator what he's qualified to answer, he's welcome. He can ask another witness and bring them in if he prefers.
So,
Okay.
Mr. Whalen, if I decide to build a 3-foot tall retaining wall, if I decide to stop at a 3-foot tall retaining wall, I should have submitted a revised POD that would have been reviewed as a revision to the minor POD, correct?
Correct.
Okay, and the building department wouldn't have been involved at all. So we would have been past this. Sorry, I should have said that. So you did say that you told me to hold off on submitting the revised POD, correct?
Which email are you referring to? 'Cause-
He already answered that question
Yeah.
and said he did not. tell
Okay.
me.
I could ask questions that have not already been gone.
Right, thank you.
Sorry, I'm just reading through my notes. What process does the county have for changes to a project once it's in flight?
I believe I already answered that, but I can answer it again if it would help clarify for you, for the board.
I just want to hear the process real quick, if you don't mind.
Okay.
Like, once I decided to build a retaining wall at all, what should I have done?
So you should
I
have,
don't need to
okay.
interrupt, but if Mr. Weiner could just ask one question at a time so that Mr. Whalen knows exactly what he's responding to.
Okay, I think that was the one question, but what is the process if he wanted to change and build the wall?
Okay. So typical process, I would say again, we're atypical in this situation, but typical process would be that an engineer or whoever's preparing the site plans would communicate with me, and they would usually issue a revision to plans, because assuming that if you wanted to add it, this is post a submittal, so we've already looked at it once, the wall wasn't there. He decides during the development process, oh, we need a wall here. I'm going to add it to the plans. So when we get a chance to look at those plans again, because they're not approved at this point, he would note, we added a retaining wall here and here. Here's the supplementary documentation that's required for us to review that wall fully and to make sure that it is compliant with any state codes, county codes, any requirements. And then that would just be it. It would just be part of the next submittal for the plan of development.
Okay, I think we understood that previously.
Okay.
Okay.
So, why did you think that I heard the customer service answer, but from, did you receive any guidance that you have discretion to, did you receive any guidance that you had discretion to wait on voiding the POD, even though the code says you shall void it?
I'm sorry, can you repeat?
Yeah, so, I know you're not a lawyer, so I'm not asking you to interpret the law. I'm just asking if you received any guidance that you do have the authority to exercise discretion and not void the POD at first, even though the code says you have to.
I'm kind of having a hard time understanding what you're trying to ask. I think you're asking me directly, like, why did I not just immediately void the POD? When I noticed that there wasn't a wall in the plans, is that correct?
Well, I guess what I'm asking is, I'm trying to ask it as a question, not make it as a statement, okay? So the point that I'm trying to make is that the whole reason that we're here right now is because you shall void the POD, when in reality, you do have some amount of discretion, correct?
Yes, as the POD administrator, yes, I do.
Okay. And how did you become aware that this retaining wall was being built in the first place?
We collaborate a lot in the county, building and myself as well. Part of my process as the POD administrator is I go out and final site plans. So I would go out at the very end when all improvements are installed, I inspect them and verify they're there. So in this situation, that hadn't occurred yet because the plans weren't approved at this point. We're still working on things. or I guess, I'm sorry, let me rephrase. The plans were approved, but the wall was noticed during inspection for the building permit. So of course, the building department communicates with me and made me aware that there was a structure that was constructed that's not on the approved set of plans. They're out on the site a lot more than I am. So that's how I became aware.
Understood.
Sorry, I just need one quick second just to find something in here. Appeal. Well, it looks like found something else is missing in here. Do y'all know when the permit was submitted, the permit application was submitted for the retaining wall at the building? Sorry, wait. 2A? Okay, sorry, I was looking at the, looking at a different section for it. So the, man, that's small. January 8th. Okay. So, sorry, one more thing. JM, do you know when the picture on Exhibit 2D, page 32 was taken?
I do not know the exact date.
At any time, did you tell me that, you know, 'cause I did offer to submit a revised POD, correct?
Would you like to refer to one of our email correspondence particularly?
Yes, if we look at Exhibit 3.
What page is that, please?
Page 43 is where I am right now. Sorry, just a moment.
I think we've already gone through these emails.
Yeah,
Is there a specific
but,
question?
so the question is, at any time did you say, hey, Evan, you know I told you you need to submit a revised POD, you need to do that, or I have to void the POD?
I'm pretty sure in one of the emails I made you aware of the violation and that what would happen, and that's why we were continuing to talk
Sure.
to try to work through it, yeah.
Yeah, so, you know, yes, you did casually, you know, you did mention that it was a violation. I appreciate you bringing that up, making me aware of it. But at any time, once your position changed, that we were no longer working together, or, sorry, I shouldn't say that way. Once the clock had run out on, or your position had changed on whether you would accept a resubmittal versus an entirely new POD, did you ever communicate the change, you know, hey, Evan, I said wait, but you need to go ahead and submit it?
And just a moment, he never said to tell you to wait. In fact, he said the opposite.
Oh, actually, if we can go to page 45. Good morning, Evan. Do you mind reading the first sentence in your email?
I think I read this already. Would you like me
Well-
to reread it again?
Please.
Okay.
Yeah.
Good morning, Evan. After speaking with building, I'm going to let them work with you on the wall before we address the POD. I
Okay,
do not-
thank you.
Okay.
Okay, yeah, so, is that, just so I understand what you were intending, were you, you know, just to reiterate it, I think you've said it, but just to reiterate, because there seems to be some confusion. You were telling me to wait on submitting a revised POD till we sorted all the details with the building department, correct?
Yes.
Okay, and after you said that, you know, we had some back and forth. At any time, did you say, hey, Evan, I need that resubmittal, or I have to go ahead and void the POD?
I did not give you a time, no.
Okay,
Just made you aware that you're in violation.
sure.
Yep.
Okay. Do you think that I relied on your instruction to wait?
There's no way he can answer
I'm
that
sorry,
question.
I'm sorry. Yeah,
I don't think that
Yeah.
Mr. Whalen has ever said, and we've gone through the emails, that he said to wait. I think he's already acknowledged that.
Right.
oh, I'm sorry, he actually just read that.
He
I
said-
believe that first sentence is insinuating of hold on.
But just to be
Yeah.
clear, that it does not state to hold on or to wait.
Right, what Mr. Whalen has testified to up to now is that
I'm going to
He
let
relied
them work
on-
with you.
yeah, he relied on, that his decision to move forward with voiding it was because building inspection said that they were not able to
They weren't
move
making
forward.
progress anymore.
And that
Right.
statement
Right.
said that he was going to rely on, that you talked to building. When that apparently quit working, he moved forward. That's the testimony up to now.
Yep, okay, so, all right, Mr. Whalen, I'm good.
Okay.
Thank you.
All right. Thank you very
I have
much.
some more stuff presentation though.
Yeah, I think.
Yeah, sorry, I'm good with you, sorry, man.
If you're comfortable there, you can stay. Thank you very much.
Board members, if y'all don't mind looking at page 113, Exhibit 6A. Down at the bottom, this is the application appealing the denial of the building permit. The date that it was filed, March 5th, 2026. Page 113, Exhibit 6A. That is when I filed the appeal for the building official's denial of the building permit for the retaining wall. And just to provide a little context and background on it, I mentioned that I built a retaining wall at my house 5 years ago. Same product. I submitted the exact same stamped manufacturer typicals that I submitted for my house, that I worked with building inspections to make sure it had all the correct information on it for a typical installation. That's what they approved when I put the product into my house. I use the same product at my yard. And so that's what I submitted for the permit when we started building it. You know, once I decided to go above 3 foot, and I knew I needed a permit, I submitted the exact same plans that the building official, oh, I'm sorry, one of the plan reviewer at the time had said was required for the retaining wall. Okay, so the point is that the day after I filed this appeal, appealing the building official's decision, okay, that is when the POD was voided. The record states, if you look at the summary from staff, it says the other way around. It implies, if you look at basically, if you look at the staff report, it implies that I submitted the appeal for the retaining wall permit after the POD was voided. It was actually the other way around. I was still trying to adjudicate the permit issues with the building official when the POD was voided. Whether that was through us sitting across the table talking to each other or through a hearing process is irrelevant. Still working towards a solution. So let me just look real quick. We shouldn't have anything else I wanted to present. I think that is it for now.
Okay.
Sorry, yeah,
All right, thank
like I
you.
said, not a lawyer.
Thank you very much. There's a lot of lawyers here, but
Yeah, only play one on a soap opera.
is there any questions from the board for the appellant?
I do have one question. Would the filing of, I'm sorry, this is
Oh, sorry.
for our attorneys. Would the filing of an appeal on the building permit issue stay any actions, stay any subsequent actions based upon the building department's based upon the appeal?
I'm sorry, I'm not sure I
In other
understand
words,
your
if
question.
the POD was voided as a result of the action of the building department, which was appealed, would the POD action be stayed by that appeal?
If I understand your question, what building does with their NOV and stop work order is separate from what the POD administrator does. They are separate. They're still separate departments. Does that answer your
I understand that
question?
they're separate departments, but they coordinated. And so you were aware that there was a violation notice and there was a stop work order, correct?
Yes.
And then you issued the POD action?
What I know is that I posted my notice of void for 3/6/26. No, I spoke with the building official. Like I said, we worked for a month leading up to this. We are separate, irregardless of what their decision was or whatever the result of the appeal. For me as the administrator, I'm looking at the code and I'm looking at working with building department, working with Mr. Weiner to try to get to a place where this was like we could fix it without happening. It wouldn't have made any difference.
I understand that and appreciate that. Thank you. I guess my question is, does the state code allow us, provide an adjudication of this appeal if the POD voiding was as a direct result of this?
Of what?
Yes.
Of what? I'm sorry, I'm not understanding your question.
Yeah, I think
I apologize. I'm certainly
Yeah.
not
Yes.
an attorney, so it's not in legal verse.
I understand the question.
Yes.
I don't know the answer.
The facts to void the POD were the presence of a retaining wall not shown on the POD. Those facts existed in February.
Yes.
They existed March 6th, and they existed even if there was an appeal going on of a building permit. The wall was there, and it was not shown on the POD. Those are the only facts, and they didn't change. So
Then
there's
why didn't
nothing.
they
in-
I guess
issue
my
the stop
concern is
immediately?
that did one action trigger the other action? Even though the zoning had the right to
Do it for-
void the POD at any time,
Yep.
but did one,
There-
did one action trigger the other?
No, the record has, because I handled the retaining wall appeal and the other appeals from building, but the record has in front of you the stop work order and the notice of violation from the building inspection. They were not put together in one day. They were coordinated, as there was not a cooperation from Mr. Weiner to move forward and just sort of arguing over accepting what he was willing to submit. A decision was made, this isn't going forward, let's go forward with enforcement actions. So they picked March 6th, but it had nothing to do with a March 5th appeal, and the POD did not have to have anything to do with the March 5th appeal. But Mr. McDonald, your question about enforcement. Enforcement is always involves some discretion. I know that speeding vehicles that police officers observed are not stopped and ticketed every single time. It is a function of whether it's customer service or resources. The government isn't harmed for not choosing the harshest action the first moment it can, but has those opportunities to consider.
I think the timeline of it looks a little compelling to the facts that maybe FOIA hasn't requested. So I have a question for you, Mr. Weiner. When you were stating there's things missing that may help this board make a decision properly, do you believe what you're waiting on from FOIA would have things pertaining to the March 5th and 6th and communications involving those two dates?
No, March 5th was
What-
Thursday, it's my wife's birthday. And the 6th was a Friday. Yeah.
I don't
sorry.
know if the board really got to the stance to hear from you, what you think you
Yeah,
may be hanging out there.
Let me put it this way. I know there was a meeting with at least 8 people in it discussing this matter. I don't know who was in that meeting. And that
Do you have an approximate date of that meeting?
early March? Oh, you told me about it. So if you want to go there, you're the one that told me about it.
If I was present, it's privileged.
Well, the existence of the meeting is not privileged, okay? But what the advice that you would give to your client is privileged. Now, who was in that meeting, when it was, where it was, is not privileged. And so you didn't share anything that was privileged with me. Sorry. You know,
Please.
like, so basically, I'm standing here, I'm like, there's 8+ people in a room talking about this at some point in early 2026, let's say, and I request documents related to any PODs that have ever been voided, and I get, the initial response was, there are no responsive documents, and I responded back and I said, how can you say that? Here's one, it was sent to me. You know, and the FOIA request was not for copies of any POD voids. It was documents related to them also. So
I think that they've already
Right.
testified there was no others
Right.
other than yours.
well,
So-
right, I understand, but to Mr. McDonald's question, I'm on a wee bit of a fishing expedition right now because I know that there is more to what happened than what is in the record, and so, you know, if you want me to stand here and believe that 8 people sat in a room and talked about this and no one wrote something down that may be pertinent to what we're discussing right now and the timing of all this, that, you know, that, I think that not having that information prejudices our case, you know?
I would agree.
Mr. Wiener, just a question, and maybe you said this. When was the wall physically built?
Ms. Cook, I can't tell you in good faith exactly when I started on it. If I may just step a little further.
Well, just a simple,
yeah, just answer that.
just maybe, I'm just trying to establish timelines.
Yeah,
In order of events.
December, January-ish.
You stated it was there in December previously.
If that's, no, I think that's what the county stated. I can't tell you exactly when I started on it. Once I decided to cross the 3-foot threshold, that's when I applied for a building permit. And that's when JM, Mr. Whalen, told me that I needed to show it on the POD. That's how I found out about the POD issue in the first place, was through staff.
And then a subsequent question, what was the barrier to getting the information that the county needed to rely on for the details of the wall? You know, obviously you thought you could use something for
Sure.
personal use before, told no, but what was the barrier to just getting what they were requesting?
Time, money, and probably a little bit of ego. I'm not, you know, I'll stand here and admit that I dug in a little bit. And if Mr. Littlefield was here also, he has said the same to me, and I think he would say the same again now. So time and money are the 2 big factors.
Okay, thank you.
No problem.
The BZA may want to know that the appeal you took resolved. I think that should probably go in the record at this point.
Oh, yeah, it was resolved in the county's favor on the retaining wall. And Casey and I sat down afterwards, and, you know, in an hour, with cooler heads prevailed. And it's unfortunate that it got to that point, you know, but I learned something, and I think everybody involved in that situation learned something.
Okay. That was going to be one of my questions, so I'm glad you already told me that. All right, so let's, any other questions for the appellant? All right, where are we at here? So, time to open the public hearing. Now we're going to open the public hearing. Those wishing to speak in support of the application, please come forward. Followed by those wishing to speak in opposition. For the record, please state your name and address, recalling the time limits of the lights. I don't see public here, so we'll open the public hearing now if anyone runs in the door.
I wish I had some cricket sound effects right now.
Okay, then we'll close the public hearing. And would the county's representative like an opportunity for rebuttal?
Thank you.
There were no public concerns, but rebuttal is still fine.
All right. Mr. Weiner had mentioned about a discrepancy and the issuance of the NOV. I just would like to point you to page 39. The actual date that the NOV letter went out is March 6th. Now, he may have known about it sooner because of Intergov, and we've already discussed how that works. Essentially, we've gone through the materials at length. There is a presumption of correctness of the POD administrator's determination. There was an approved POD in June of 2025. The POD did not show a retaining wall. It was required to show one under the code section 314B7. The wall is a 100-foot, 6-foot wall. In December, staff noticed this wall, and so then Mr. Weiner tried to file a permit for it, which was unsuccessful. And I showed you a picture of the retaining wall on his new site plan. The code says that if you don't have a retaining wall on the approved POD under section 15-326, it shall be voided by the POD administrator. It doesn't mean he has to do it that second. It doesn't mean he has to do it a month later. Our policy here, our mission in the county is superior customer service. We go to great lengths, and Mr. Whalen spoke to that, of working with customers to save them time and money. Mr. Weiner testified that the hiccup for this was time and money. We really tried to circumvent that and help him from having to go through so many cycles of reviews, because multiple departments have to review these PODs. It has to go through a whole process. That process didn't happen like it typically does, as Mr. Whalen testified, because it was already built. It was already constructed. So they're trying to figure out how can we work with him and save him time. Finally, when Mr. Weiner was not cooperating with building or with planning, with the POD administrator, and he mentioned that, his ego was getting in the way. He wasn't complying with their simple request of what needed to be provided. Mr. Whalen finally issued the notice of voided POD in accordance with section 15-326. That determination was correct. And so your decision today is only to determine whether his decision to void the POD was correct and nothing else. Thank you.
Okay, thank you. Mr. Weiner, would you care to make a rebuttal?
We're on rebuttal now, right?
This is your rebuttal, your
Okay.
last opportunity.
Yeah. Well, we have closing remarks also still, right?
Oh, you are correct.
Okay, sorry, just want to make sure, because, yeah. Okay, so first things first, Intergov. There's not a copy of the POD void notice in Intergov. There's not a copy of the notice of violation of stop work order on the building permit in Intergov. I did not have a heads up that this was about to happen. I lost my cool when the building inspector showed up to post the stop work notice. I lost my cool so bad that weekend I emailed Ms. Parker and said, "Hey, would you please get word to the inspectors that came out and pass along my apology for the way I handled myself." I did not handle myself the right way, and I guarantee you, if I had known about it being about to happen, I would have submitted the revised POD before the notice got posted. Ultimately, what this boils down to is, Evan, do this. I changed my mind. And no one tells me to do this, okay? I didn't know. I realized the retaining wall is a requirement on the POD application and in the code. I know that now. I did not know that at the time that I started building a 3-foot tall retaining wall that then became 6 foot. And for the record, at the time that staff was out there in December or January, the reason they were out there to look at it is because I filed for the permit to build it, and that gave them the legal authority. Well, I'm not going to go there. That is why they came out. That is why these photos exist. The photos of the retaining wall exist because I was trying to do what I needed to do. I had already filed for the building permit. counsel for the county is saying that, yeah, there's some discretion. We have policies here. The problem, though, is that in the same token, they're saying, well, we have to follow the law. So policy, we may not follow the law at first, but we may get there and follow it later on. It's the code does not say staff will try to work with the applicant and then do this. It said, we'll do this. So the discretion is there. I would have submitted the revised POD had I been told to. The county also says that there was no more cooperation with planning. That's because I hadn't had any conversations with them. I was trying to work with the building official, and things had gone sideways. So it's not that I was dodging Mr. Whalen. I wasn't ignoring him. We had nothing to talk about until I sorted things out with the building official, which was what he told me to do. That's it for now.
Okay. All right. Let me move on to the next. So I guess we're at closing statements now. We didn't have any public that you guys are responding to, but it's still
Respond
okay.
to each other.
That's okay. You're both part of the public as well. So closing statements, the county would like to go first.
Yes, thank you. So I've already mentioned the board's authority is to determine whether the POD administrator's determination was correct. We had the POD, the approved POD, no wall, and the code says he can void it. There's no time frame on when he has to make that determination. He was working with Mr. Wiener trying to sort this out. The approved POD was in June of 2025. Mr. Whalen didn't void that all the way until almost a year later of March of 2025. So he had been working with him for a very long time trying to get this taken care of. He told him in the note in his email, and we read it to you, hey, you're in violation, and it's this particular code section. When we talk about notice, Mr. Wiener said no one told him that they were going to void it. Police officers and other instances don't give you notice, hey, I'm going to give you a ticket. It's coming. The notice is the notice that was issued on March 6th. That was when we let him know. We don't give him a heads up. That's not required. Even if Mr. Wiener talked about a 3-foot wall, if he had built that, that still required a building permit. Any way you look at it, he had an approved POD with no retaining wall. It wasn't on there, and he was required to show it.
I think you misspoke just a minute.
I'm sorry.
The 3-foot retaining wall was required to be on the POD.
Oh, sorry, be on the POD.
I knew you misspoke.
Thank you. Yes, it was required still to be on the POD. It doesn't matter that difference. It still was required. He knew it was on there, and we had gone out in December, and so he had time between June and December to notify us, and he didn't before it was fully constructed. Mr. Wiener has the duty or the burden to rebut the presumption of correctness of the POD administrator's decision, his determination to void the POD. He hasn't met that. We have shown you it's approved POD, no wall, the code says you can void it, and that's what Mr. Whalen did. So we're just asking you, sorry, to get my thoughts together, much has been added, it's back and forth, that on this appeal, we're asking you to uphold the POD administrator's decision that it was correct, and that we have shown you his reasons for doing so and his coordination of all the different departments and how this was a very backwards process. It's not the norm. And so we ask for you to uphold the POD administrator's decision. Thank you.
All right, thank you. Mr. Wiener?
All right, here we go. Okay, so I want to try to, 5 minutes, right?
5 minutes.
Okay, thank you. I want to try to correct one thing. Counsel for the county said June all the way to almost a year later into March. Well, that's not accurate, okay? The POD was issued in June. The retaining wall didn't come into the picture until December, January 25, 26, okay? I didn't even think about building it until then, much less start on it, much less know that I needed to come back to the county to put on the POD and much more amicably resolve this, all right? So that timeline is very much exaggerated. It's 3 or 4 months. It's not almost a year. I get in arguments with my wife about rounding on our kids' ages. You know, if their birthday is tomorrow, she's gonna say they're 8, even though they can be 9 tomorrow. I'm like, almost 9 is very different than 8. You know, so the point was raised about, you know, does a police officer say, I'm going to pull you over and write you a ticket? You know, there's a big difference here. This is civil versus criminal. And while I think this is civil versus criminal, while there may potentially be criminal penalties for not resolving it, okay, if a police officer pulls you over and says, I'm going to give you a warning, slow down, and you slow down, they're not going to pull you over 5 minutes later and write you a ticket again, are they? You're just going to go on about your day. So that's ultimately what this comes down to. You know, the instructions that I was given, I relied on them. Whether the POD administrator could have or should have or whatever, the POD in December or January, it's not what we're talking about. What we're talking about today is a written instruction from the POD administrator to do A and then do B. And that's what I was still trying to do at the time that the POD was voided. There was an appeal pending that was properly filed with the building official, and that appeal had not been adjudicated. I was still working through the process and still trying to do exactly what Mr. Whalen had told me to do. It was also not fully constructed at that time. And I'd also committed in writing multiple times to hold off on anything related to that retaining wall until we sorted things out. So that's what this all boils down to for me is it's not a matter of whether the POD administrator had the power to do what he did. I agree, he had the power to do what he did, but if he needed to do it, he should have done it in December or January, not said wait. I took that specific instruction that was emailed to me, and I listened to it, and I was trying to sort out the building official issues. And I'm not saying that I handled all of it the best way that I could, but that's what I was trying to do. And I've gotten through the building official issues, and just trying to get this all moving again, so that I can build a building, grow my business, continue providing services to citizens in the county. You know, I know you don't live where you lived anymore now, but at the end of the day, this is about a local business trying to grow, trying to do things the right way, not always checking the box in the right order, because I don't know, you gotta check this box before I go to this box, because they're on 2 different forms. So if I fill out Form A first, and then someone says, oh no, you gotta fill out Form number 1 before Form number A, that's basically how this whole thing got started. I tried to fill out one form, not knowing I had to fill out the other form first. Yeah, appreciate your time today.
Okay, thank you very much. So we'll turn it back to the board, and do we have any questions for anyone from the board?
Yeah, I do have a question, Ms. Whalen, if I might. On the POD, would you have accepted a POD or a revised POD with 2 options for the retaining wall, either a 6-foot or a stepped 2-3-foot option?
I suppose, they're allowed to submit whatever they want.
Yeah, I mean, a retaining wall is a retaining wall in that case.
If he submitted something to me, yeah, I would accept it. Now, whatever happens in the review is, I don't know, but I would.
I appreciate that. All right, thank you, that was my question.
Okay, any other questions? And what I'd like, this is a fairly complicated hearing. And so I would really like, and I think it'd be a benefit to hear a little bit of comments from everybody, and maybe if I could just start from my left, and if you worked our way down, and maybe just have you make a few words about what you're thinking, and before we have any motions to consider, then we can consider that, if you have any comments.
Right now, and I think I'm siding with the county, that he acted with his within his rights, within what he's obligated to do within his position. The only question I have is a little bit of the question of the missing link, but I don't know that we have any information from Mr. Weiner that's going to provide additional information to change my decision.
Okay. Mr. Rosenberg?
I'm leaning to agree with the determination of the administrative officer in this case. I think that you know, the county regulations are clear. The officer had the opportunity to avoid the POD at any time once the violation was determined. I think the appellant could have made accommodations in the POD for the various issues related to the, whether it was a 3-foot high wall, or a 6-foot high wall, or a step to 3-foot high wall, that would have made the process move smoother, given the time period, even if it's December through March. That's a long time to work if, you know, to make a resolution that can accommodate both parties. While I do think the timing is a little strange, that doesn't necessarily obviate the administrative officer's presumption of being correct, and he probably, yeah, I think he was.
Okay, Ms. Cook?
I agree with the comments made already. Probably the only additional thought is the appellant, Mr. Weiner, you had personal experience with building a retaining wall and knowing permit requirements. Why things were done out of order just made your life more difficult and probably wouldn't be in this situation. So I feel like the arguments are about where the county was trying to be accommodating, and I don't feel like, I'm not sure what else could be done. So I'm in agreement with the others.
Okay. Mr. McDonald?
Well, first of all, I think we should all consider if there are going to be any documents produced from a FOIA investigation with proper documents being released. Secondly, I really think that, you know, Mr. Weiner, I think you really probably ruffled some feathers within the county. I think between the meeting that's not being disclosed and the timing of the appeal that you put in and the timing of the POD, which when the POD gets canceled, it just shuts everything off. So the timing of the appeal being applied, you already ruffling people's feathers, I about can believe and only assume what would go on in a 8-person meeting about this topic, and then for the dates to add up on what happened within the county, there was a little bit of a game played with your situation. There should have been a decision made on your POD with maybe a little more communication with you up front. Hey, I'm going to give you another week, but by next Friday, if you don't have this, you know, revised, where I'm going to put a stop order on it, you know, that it just smacked you in the face. Out of all the communications, you're not exactly in the clear, but the county's definitely not in the clear. They played the game with you, but they're the rule holders to the game. But it left you hanging out there to say, hey, I didn't know when the clock was stopping on the end of the game. You didn't tell me when the clock was stopping. That's a county issue. That, I mean, just to do it in the timing that it come up, I really feel like it's a disgenuine service to the citizens, that whether he was ruffling feathers and probably not doing the right thing to the T, two parties have let each other down. But in this situation, I believe that POD should be reissued. I think go back through the appeal process with the retaining wall, and then kind of maybe conduct it in a little bit better way that would be more amicable for the, you know, county wanting to maybe work better with you. But I do think there's a huge game being played here, and I would agree with you that you should be able to continue your services with the POD.
Okay, thank you. Just a point of clarification, Mr. Weiner nodded to me earlier about we did have a previous, he provided internet service to my previous home. I moved out of a couple years ago. I just want to make sure that the record is clear about what he was referring to, that we're in no business relationship at all. I have nothing, no stake in this hearing. Yes, just want to make that clear because he just made a little reference to it. But so the way I see it, quite honestly, is it seems very simple to me. So the wall is there. When the wall is built, he's going to need a new plan anyway. So the only way to remedy the wall being present is to create a revision of the plan. So he's going to have a new plan. And so whether we do it, whether it gets voided and he gets a new plan, or whether he just creates a new plan from the start, he's going to have to create a new plan. And so I think the county's staff absolutely acted, I think, above probably what they needed to do to make this work out. And I'm sure that, as Mr. McDonald said, you probably ruffled some feathers, and that made everybody sort of stop the process and maybe not be as amicable to bending over backwards. But they didn't have to bend over backwards. It's not necessary for them to do that. And so they were doing it to be nice, and when things weren't nice anymore, it sounds like they decided, all right, we're just done. And I think they're within their right to do that. Certainly they're within the statute to do that. And we have to presume that the county staff is correct in their decisions. And I don't think you've given anything to, in fact, you stated in one of your statements that they have that right to do, and that's the end of it as far as I'm concerned. That we've reached this point is maybe as Mr. McDonald said, there's personalities that got us here, but either way, the statutes are the statutes, and the county has that opportunity to void it when you're not following the plan that you developed. And so I would certainly agree with just staying with the decision of the county. But be that as it may, if someone has a motion, if there's no other, I guess I'll say if there's any other comments, then we should entertain a motion from someone.
I move to uphold the March 6, 2026 determination of the POD administrator avoiding the POD-2024-00019.
Okay.
I second.
Motion by Mr. Rosenberg, second by Ms. Cook. Sorry, I got that wrong. Yeah. So is there any further discussion on the motion? If not, then maybe we'll have a roll call vote.
Sure. Mr. Rosenberg?
Aye.
Mr. Babbitt?
Aye.
Mr. Boatright?
Aye.
Ms. Cook?
Aye.
Mr. McDonald?
Nay.
The motion to uphold the March 6, 2026 determination of the POD administrator voiding POD 2024-19 passes on a 4-1 vote.
Okay, thank you. And wish you luck with trying to get your situation all sorted out there. So that will take us to unfinished business. Is there any unfinished business? Ms. Parker?
There is no unfinished business and there is no new business.
Ah, awesome. So now we need to review and approve or amend the minutes from May 18, 2016, or 2026, sorry, decade off. For once, we actually have very in-depth minutes.
I motion to approve the minutes.
Okay, Ms. Cook, motion to approve the minutes.
Second.
Second, Mr. Boatright. All those, do we need a roll call for that, or?
We can do that.
Okay, seems excessive, but that's all
Mr. Babbitt?
right. Aye.
Mr. Boatright?
Aye.
Mr. Rosenberg?
I abstain.
Mr. McDonald?
Aye.
Ms. Cook?
Aye.
Thank you.
Okay, I think, seeing no other business before the board, the meeting is adjourned.